Good afternoon, everyone. Thank you for registering for today's webinar on the New York Paid Family Leave Law. Today's session will be presented by the co-chair of Garfunkel Wild's Litigation and Arbitration Group, Roy Breitenbach, and the co-chair of the Employment Law Practice, Marianne Monroy. Today's presentation will run approximately 30 minutes. Please use the chat box in the upper right-hand corner of your screen to post questions. If time permits, we will answer as many questions as possible at the end of the presentation. All other questions will be answered via email. A replay of this presentation will be posted to the Garfunkel Wild's YouTube channel, and we will email that link in the coming days. Again, thank you for registering to Garfunkel Wild's webinar. Now over to Marianne.
Thank you, everybody, for joining us. So Roy Breitenbach and myself will be giving this presentation. Just briefly about the two of us. Our practice is primarily focused or largely focused on handling employment law questions, counseling, and employment advice, as well as defending our clients in employment litigations ranging from discrimination to wage and hour issues. I'm going to jump right into the material right now since we do have a limited amount of time with this webinar. To start with, we have received many inquiries from clients about whether this law applies to them and how it will affect their business. If you are a private employer, this will affect you. We anticipate that there will be an increase in employee leave requests given the pay component of this law, which is not available under other leaves covered under the federal FMLA leave law. The law is fairly technical and it has a large set of regulations, which would take far more time to discuss in detail than this webinar. However, we do want to have you take away a firm understanding of the basic components of the New York State Paid Family Leave Law, which I refer to as the PFL, including the types of employee rights, such as the length of the leaves, rights to continued health care coverage, reinstatement rights, as well as the eligibility requirements we will review as to who is covered. We're going to review the funding and implementation. As some of you may already know, this leave law is being phased in over time, so it will start with an 8-week leave benefit growing to 12 weeks over time. We are also going to discuss distinctions and interplay of the state PFL with federal FMLA leave, as well as New York State disability laws such as workers' comp and short-term disability benefits. While there are similarities, be wary that just because you may comply with the FMLA does not equate to compliance with the PFL. We are also going to discuss some practical applications and scenarios that we anticipate arising under the new law. For example, there are situations when a leave may qualify under both the PFL and FMLA and therefore run concurrently. But there are circumstances where an employee may be able to stack time, run it back to back, and stretch the leave entitlement beyond 12 weeks over a 52-week period, which I'm sure gives some employers some concern. And finally, and importantly, we're going to give some recommendations and steps to achieve some compliance. We want everybody to understand there is a lot to absorb, there's a lot to digest, but we are available to help you through and answer questions as they may arise. You should also take some comfort in the fact that there is still some time, although not a lot of time, to get prepared and meet the requirements of the law. Okay, actually, I should have had the other slide up. I'm going to move to the next slide, highlights. So to start off with, before we drill down, I wanted to give you a few of the highlights. So Governor Cuomo signed the PFL into law April 4th, 2016. However, it does not take effect until January 1st of the upcoming year, 2018. The regulations were only issued this past July 2017. The PFL is contained within the New York State workers' compensation law, but it is not a workers' comp benefit, which most people are familiar. Workers' comp provides a monetary benefit for on-the-job injuries. It's also distinct from New York State short-term disability, DBL, which provides, again, a monetary benefit for injuries that or illnesses occurring off the job. So this is a distinct added benefit. It is, I wanted to highlight, one of the nation's most comprehensive paid family leave laws. Unlike other states, such as the state of New Jersey, the leave laws are generally unpaid. So this is a significant distinction. Another highlight, it's applicable to basically all private sector employees, while other laws like FMLA have a minimum threshold number of employees. This one does not. It also provides protected leave while you're out. So unlike workers' comp and New York State short-term disability, that's solely a monetary benefit. So if you're out on short-term disability for the birth of a child, you are not guaranteed under those DBL laws to reinstatement. We will also be talking about the funding of this law, and as I'm sure many of you will be relieved to hear, it is funded exclusively through payroll deductions, employee payroll deductions. So now we're going to move to the next slide here, talk about some of the substance of the PFL. So to start off with who's covered as by virtue of employers. So private employers are, if you have at least one employee, this law is going to apply to you. So if you're required to have DBL coverage or workers' comp coverage, you must assume you are going to need coverage under the PFL. There are some circumstances where a business may be owned by one person and have no employees and they don't need workers' comp. In those circumstances, you wouldn't be required to get the PFL. Just to mention, there is an opt-in provision that's provided for under the statute for public employers. We're not really going to address that in any detail today, other than to mention that if you are a public employer and you want to opt in, there is a process set forth in the regulations to opt in and allow for public employees to make those contributions. So moving to more of the heart of it, the eligibility requirements with respect to employees. So employees who work at least 20 hours per week are eligible after 26 weeks of consecutive employment. Employees who work fewer than 20 hours are eligible after 175 days. So clearly this regulation, this law is designed to capture a broader range of employees and capture as many people as possible. There is one narrow waiver exception or provision within the regulations that may allow an employee to opt out. And again, if you meet the eligibility requirements, you can't opt out even if you want to. So you might have some employees come up to you and say, no, I don't want to make that contribution. Don't deduct it out of my paycheck. I'd rather not have the coverage. It's not going to be optional unless we can establish that that employee won't be able to meet the eligibility requirements. So that might be just limited to your seasonal or temporary employee hired to work maybe a month during a holiday rush season. However, keep in mind, first the waiver would have to be in writing. If it's permissible waivers would have to be writing. And then if there's a change in circumstance that would allow an employee to later become eligible, where, for example, that seasonal employee is offered a full-time or part-time position that would allow them to work the 26 consecutive weeks or 175 days, then the waiver has to be revoked. And it has to be revoked within 8 weeks of the change in circumstances. And the employer must start taking the contributions out of the payroll from the employee retroactive to the date of hire, or as soon as the employee receives notice of the contribution obligation by the employer. Okay. The next thing we want to talk about today is qualifying reasons for the PFL. So similar to the FMLA, the federal FMLA, PFL provides employees with leave to care for a family member with a serious health condition. Those of you that are covered under the FMLA are fairly familiar with that process, I would imagine. This law is a little bit different. It defines family members to include a broader group of individuals, such as grandparents, grandchild, domestic partner. The regulations also specify the types of care that are covered for leaves related to taking off for a family member with a condition. And it could be everything from physical care to transportation, daily living, dealing with daily living matters. So, for example, under the PFL, if you need to transport a family member to and from treatments, maybe they're getting physical therapy or cancer treatments, that would be covered. The law also covers, similar to FMLA, bonding after the birth of a child, adoption, or foster care. The leave expires after the birth of a child after 52 weeks from beginning as of the date of the birth. With respect to adoption and foster care, it's either 52 weeks beginning as of the date of the placement or the start of the leave. That's how long the period of time within which you can take the leave. So this law is not going to cover pregnancy complications when an employee is out for their own medical conditions related to pregnancy, but they may still be able to get short-term disability benefits. And it also covers qualified military events and exigencies, the same that would be covered under the FMLA. And it extends to the employee's family members, including the broader range of family members, such as the grandparent, grandchild, parent-in-laws, people of that nature. So now I'm going to pass the presentation over to Roy, who's going to pick up where I just left off.
Okay, thank you, Marianne. I'm going to start now talking about funding. As Marianne explained, a little different than some other workers' benefits provisions, the PFL permits it to be funded through employee contributions. So it's strictly an employee contribution benefit, and businesses may start deducting employee contributions. They could have started deducting those contributions as of July of this year for coverage starting in January. And similar to the disability benefits provision, employers can decide whether or not they want to provide the PFL benefit on either an insured or a self-insured basis. If employers want to provide it on a self-insured basis, they have to apply with the state by the end of this month. So you only have a few weeks left. And employers who self-insure are responsible to cover any shortfalls if the payroll deductions do not suffice. And for self-insured employers, there's obviously more benefit to collect contributions sooner than later. So that's with regard to self-insurance. It's important to note, though, that you can't have a different approach to disability insurance and self-insurance. So if, for example, you provide disability insurance on an insured basis, you can't do PFL on a self-insured basis. So that has to be a unified treatment. And then on the disability insurers side, disability insurers do have to offer all of their policyholders PFL coverage. And just for employers to recognize, there are some significant risks if you're going to self-insure, because employers who self-insure are responsible to cover any shortfalls if the payroll deductions are insufficient. You really can't predict the volume of claims to expect, because this is a brand new benefit. We're kind of flying without a parachute here, but we do know that the current maximum weekly contribution for at least the first year is going to be $1.65, and the current maximum PFL benefit will be just over $652. We'll talk about how that's going to be calculated in a little bit. So let's talk about employee payroll contributions in a little bit more detail. As I said, they're currently capped at $1.65 a week. This figure is based on a rate which was set as 0.126% of the employee's weekly wage, which can't exceed the statewide average weekly wage of $1,305.92. These contributions amount are going to change annually. So, for example, for 2019, it may be more. than $1.65. The rate's going to obviously depend upon the actuarial experience that people have with the law. So turning to the next slide, which talks about leave implementation, benefit pay schedule, and how it works. Like a lot of the recent benefits that have been enacted by the state in the employee area, it's a phased-in implementation. So what that essentially means is that in January of next year, January 2018, employees will be entitled to 8 weeks of paid leave at either 50% of the employee's average weekly wage or 50% of the state average weekly wage, whichever is lower. And since the state average weekly wage as of this year is $1,305.92, it means that the cap on benefits that an employee would receive under the PFL would be $652.96 a week. And what's particularly interesting with that is more than what an employee would typically receive in short-term disability benefits. So then, of course, in January 2019, the benefit increased to 10 weeks of paid leave, and that would be at either 55% of the employee's average weekly wage or 55% of the state average weekly wage. And of course, the state average weekly wage could change by 2019, so that could be greater or lesser than it is today. Then in 2020, it goes up to 60% of the employee's average weekly wage or 60% of the state average weekly wage. And finally, in January 1, 2021, when the statute will be fully implemented, an employee will be entitled to 12 weeks of paid leave at either 67% of the employee's average weekly wage or 67% of the state average weekly wage, whichever is lower. And again, probably consistent or concurrent with the way the amount of leave goes up and the percentage of pay that you receive for that leave goes up, the employee contribution rate will also likely rise. So let's now go to talk about some other issues regarding this, including the duration of paid family leave. This is a complicated area. So essentially paid family leave is measured in weekly increments. As we discussed before, you get 8, 10, or 12 weeks, depending on what year it is. An employee is eligible for the maximum number of weeks under the PFL in a 52-week period. So if the benefit is, for example, 10 weeks in a given year, an employee can only take 10 weeks of PFL in any 52-week period. Now, it recognizes that in many cases, while the statute talks about weeks of leave, you have to take into account the employee's work schedule. For example, if your employee works 2 days a week, then a week of PFL leave for them is 2 days. And you also have to take into account the fact that leave is not always going to be requested in weekly increments. Many employees will ask to take PFL in daily increments. You have to remember, though, that the maximum period of paid leave is based on the average number of days worked by an employee, up to 60 days. For example, if an employee who works 3 days a week as of January 1, 2018, the employee may obtain 3 days of paid family leave for up to 8 weeks or 24 days in a 52-week consecutive period. So it's going to be a little bit confusing as to how to calculate that, and it requires some care so that you don't run afoul of the provisions. So turning next to a hot button issue in terms of employers' exposure, we'll talk about protected job leave and continued health benefit. Similar to the Federal Family and Medical Leave Act, the PFL provides for job protected leave, which means that when an employee takes PFL, they're entitled to reinstatement to the same or comparable position prior to taking the leave, with analogous benefits, pay, and terms of employment. And as we've consistently recommended with regard to FMLA, there is always a potential risk to an employer in changing the employee's position upon return, because that may cause a dispute as to whether or not they're being reinstated into a similar position. So great care has to be taken in this subject, and consultation has to really have with human resource professionals or attorneys if that's what you need to do. And also, like the FMLA, if you can establish that the position would have been eliminated or the employee would not have had the position if they didn't, even if they didn't take PSL, you could PFL, excuse me, you could get out from under the protected job leave requirements. But again, that will take some careful professional analysis. Employees are also entitled to the continuation of group health insurance under the same terms prior to commencing leave. If there are new plans offered or added health benefits that are given within the period of paid family leave, the employee is entitled to participate like other employees not on PFL. And like the Family and Medical Leave Act, retaliation and discrimination are prohibited under the law. So we anticipate to see an increase in litigation claims that are based out of alleged retaliation for purposes of taking PFL. And so now I'm going to turn it over to Mary. Now I'm going to turn it over to Mary Ann to talk about the application procedures.
Okay, so everyone should be prepared. There is going to be some more paperwork. You're all used to filling out forms, or most of you, with regard to disability benefits, workers' comp, and FMLA. So now there's going to be another set of paperwork to deal with for the PFL. There's also some employers are expressing concern about, how much notice they are going to get from their employees who want to take this type of leave. So the regulations do address that. Employees are required to provide 30 days notice to their employers prior to taking PFL leave for foreseeable events. So in cases of the birth of a child, it would be foreseeable to know when the birth is anticipated, and the employer should get at least the 30 days advance notice. When the employee fails to give the advance notice, the regulations do provide a provision that would allow the carrier or the self-insured employer to partially deny the leave request for a period of time, up to 30 days from when the notice is actually given. Again, this would be an area that you would want to carefully assess before you deny a leave request for insufficient notice. On the flip side, there will be situations, and we expect employees to state that the leave is not foreseeable, it's unforeseeable, and give notice less than 30 days. The regulations do allow for that to happen. There is some language that talks about where it's an event or incident that happens that's not foreseeable. It is expected that it would be practical to give the notice the day of the event that caused the leave or the day after, but it is fact specific, and the regulations leave open the door that it may require a lengthier period of time. Employees will be required to complete a request for paid family leave, a state form. It will be submitted to the insurance carrier or the employer if self-insured. We anticipate that the state will issue some final versions of forms, including the request for paid family leave. There will also be forms that will be involved in the administration of processing the claim, including healthcare provider certification forms. Employees will also be asked, when appropriate, to provide other documentation, such as if they're going out related to a military exigency, they could be required to provide copies of active duty orders to support the PFL leave request. And this is all very similar to what is required of the FMLA. There are some tight deadlines, and they're not the same deadlines that FMLA implements. So when an employer receives a request for the need for leave, they have 3 days to provide certain paperwork back to the employee in connection with the administration of that claim. And then the regulations require that the carrier or self-insured employer within 18 days of claim submission that they either pay or deny the claim. And if they're denying it, specify the reason for denying the claim. So we do want to caution everybody to start gathering your forms and getting ready for when you need to process these claims, which we would expect.
Okay, so now I'm going to talk a little bit about the notice requirements and what employers need to do. So if an employer, as an employer, if you maintain an employee handbook, and we've consistently urged every employer to do so, you must update your employee handbook to include a PFL policy that sets forth the employee's rights. We, of course, can help you with that. Absent a handbook, if you don't have a handbook or other written guidance addressing employee benefits, you need to provide a separate notice stating an employee's rights under the PFL. Very important to do this to avoid having a claim later on that you gave inadequate notice to an employee and therefore the employee was unaware that they could take PFL, which could result in some significant monetary exposure to the employer. And you must post a PFL notice in the workplace. It must be in plain view. It can't be posted in a locked closet or inaccessible part of the office. We're all waiting for the state to issue form notices. Many of you probably use the Department of Labor form FMLA notices, and so we anticipate that the state will issue similar notices under the PFL. And we would recommend once the state issues these notices that employers use the state-issued forms so there's no dispute over the adequacy of the language of the notice that's posted. And then just for those employers who may be listening who have a unionized workforce and are under the terms of a collective bargaining agreement, please note that if your employees are covered under a CBA, the employer must coordinate with the union regarding how to calculate payroll deductions and how the PFL is going to apply. So that's something you'd have to take care of, and presumably you should take care of it as soon as possible because the latest that the payroll deductions will begin is supposed to be in January. So with that, I'm going to turn it over to Mary Ann to talk about the topic of the interplay between the PFL and the FMLA.
Okay, so this is an area that a lot of our clients are asking questions about. So we're going to give you some of the highlights here about the interplay and some of the similarities, distinctions. So the FMLA provides the unpaid leave benefit only, while the PFL is a paid leave benefit. FMLA, of course, applies to employers with 50 or more employees within a 75-mile radius. While the PFL applies if you have just one employee within the state of New York. On that note, if you are a business that is located outside of the state of New York, but you do have employees within the state of New York, you are required to comply with this law. The eligibility waiting periods for employees is also shorter under the PFL. So an employee may be eligible for PFL after 26 weeks of working, about a half a year, in comparison to FMLA not applying until 12 months or 1,250 hours of work has been accomplished. So there may be some requirements where an employee may go out onto PFL for the birth of a child, but not yet eligible under the FMLA, and that FMLA leave entitlement is going to remain intact. Another important distinction is that the PFL defines family member more broadly, as I mentioned before. So it's not only going to capture the spouse and the child and the parent, but it's going to capture the parent-in-law, grandparent, child, and domestic partner. So again, in some instances, depending on the family member who is involved, PFL may apply and FMLA may not. With FMLA, the employer also basically administrates the leave request. They determine if the leave is qualified under the law and designates or approves the leave. Unlike FMLA, the insurance carriers, if you're fully insured, is responsible for administering the leave. Forms are submitted to the carrier. The carrier will request additional information if appropriate, and the carrier ultimately renders the determination. Another important thing to keep in mind is that employees may be required to use FMLA leave and PFL concurrently. And this is important, and employers want to make this happen to avoid very extensive leaves of absences for basically the same event. But it is important to have that happen and to have them run concurrently, that you have clear policies that provide for that. So you don't have a situation where someone takes off 12 weeks for the birth of a child under the PFL, followed by another 12 under the FMLA. So another important thing to keep in mind in your assessment in issuing the forms and determining what's covered, whether or not the leave is qualified under both statutes. So you really have to take a close look at that. So one example I can think of is an employee may maybe take 2 weeks of FMLA leave for back surgery, so that's for their own serious health condition, followed by a full 12 weeks of PFL for bonding with the child within the same year. So again, there are circumstances where they're going to run back to back. And it is important to designate to limit the ability of an employee to really extend out those leaves and have all the appropriate time counted against the PFL entitlement. Okay, as mentioned before, there's also employees who are currently on FMLA leave or took FMLA leave in 2017, for example, maybe in the connection with childbirth, may be eligible to take PFL for the same exact reason when the new law goes into effect in January 2018. So someone who had a baby in May of 2017 used up their entire 12 weeks may submit a request to you for additional time off in connection with that same birth this coming year. And that is something that employers are going to have to address and provide. Okay. Right. PFL also, another distinction in Interplay is the concept of intermittent leave. And so you may be familiar with intermittent leave under the FMLA. PFL also will permit for that. However, under the PFL, leave may only be taken, the shortest increment is 1 day, while under the FMLA, it may be taken in lesser increments than 1 day. So you do, of course, want to have the leaves run concurrently as much as possible. What employers can do is take into account the shorter intervals. And once you're out on FMLA for the equivalent of 1 day, you can apply it against the PFL leave entitlement. So, for example, if an employee is out for 2 hours, 4 days a week for physical therapy, at the end of that week, they've worked enough time to count against the PFL, the equivalent of 1 day, in addition to the hours taken under the FMLA leave. So again, that's something you want to take a close look at and make sure you're really you're applying all the leaves where appropriate. Another distinction too between the two and the Interplay is that under the PFL, you cannot collect PFL benefits during a period of time when you were working for pay or remuneration. This is a little different than the FMLA. I mean, most of the time people go out on FMLA leave and they do not work. However, the FMLA does allow that if you're working, you might be put out on FMLA leave due to a back injury or a particular condition that renders you unable to do one job, but that you may necessarily be able to do a different job. So for instance, if you can't do the warehouse job, but you can sit at a front desk and maybe answer the phones, you may be able to do that other ancillary job and with another employer and make some money and still not jeopardize your FMLA leave with the other employer. That doesn't work with the PFL. So again, there is a lot of overlap. There is also a lot of similarities, but it is important that you really take the time to assess the distinctions and make sure that everything is being applied appropriately with these two statutes.
Okay, thanks, Marianne. I'm going to talk about the interplay now between PFL and disability benefits. As we've said repeatedly during this webinar, the PFL does not offer paid leave benefits to employees in connection with their own serious health conditions. So for an employee's own serious health conditions, employees have to rely on short-term disability compensation. There may be instances, though, where an employee may select one benefit over another. For example, an employee may elect to receive disability benefits following the birth of a child, related to postpartum or while they're in the hospital, followed by PFL for a period of time thereafter for bonding with the child. Under the law, employees may not receive more than a combined 26 weeks of disability benefits and PFL during a consecutive 52-week period. So the ability to stack short-term disability benefits and PFL is limited. There's no duplication of benefits. Employees can't receive PFL and disability compensation simultaneously for the same period. There's no double dipping. Likewise, there's no double dipping with regard to PTO. If an employee uses their saved paid days off to receive 100% of their salary during the PFL period, an employer may request reimbursement from its insurance carrier to avoid the employee getting paid in excess of a full day's pay. If the employer is reimbursed the PFL benefit due to the employee's use of the PTO benefit, there is an argument to be made, although this hasn't been conclusively decided, that the employee may be entitled to have their PTO bank replenished for the time increment equivalent to the reimbursement received by the employer. Everyone is waiting for more state guidance on this issue. Now I'm going to turn it over to Mary Ann for enforcement and penalties.
Okay, so I know we're running a little short on time, so I'm going to just quickly move through this. I mean, everybody should be aware that there is some potential liability that could be significant in nature. I do want to mention that the PFL, as I mentioned before, is contained within the workers' compensation law. So claims and disputes, including discrimination claims, eligibility and benefits, they all fall under the purview of the workers' comp board, subject to arbitration. Just like people have brought claims for discrimination based upon filing a workers' comp benefit claim, there are protections for the same types of discrimination and retaliation claims for using your PFL. The penalties for failing to provide coverage can be, according to the regulations, 0.5% of an employer's weekly payroll for the entire period during which there was no coverage, as well as a $500 fine. The fine is less troubling than the amount of the 1% of an employer's weekly payroll, depending on the size of the company, could be quite significant. The other major penalty or potential liability is that if you don't have the coverage and you were supposed to have the coverage, the employer is responsible for paying the benefit claim. The employer can then not seek the reimbursement of the contributions from the employee during which the period that there was no coverage. So the employer is on the hook to pay the entirety of that benefit claim.
Okay, let me talk now finally about recommendations to prepare for compliance, which I'm sure everybody is waiting for. Okay, so if you haven't already decided, now is the time to decide whether or not you're insuring or self-insuring coverage, right? Because your deadline for self-insurance application is the end of this month, which is about, by my count, 17 days away. If you are insuring, you need to contact your DBL carrier and add the coverage. It should be included as a rider to your current DBL policy. And if you are self-insuring, you have to submit the application, as I said, by September 30th. Next thing you need to do is update your employee handbooks and policies to include the additional information addressing PFL. At bare minimum, you need to prepare and disseminate a policy addressing PFL rights no later than January 1 of 2018. You also have to obtain and post a PFL workplace notice by January 1st. It is our expectation that the state will issue a model notice shortly, so you can use that. And then you have to ensure that the payroll systems are prepared to make appropriate deductions from the employee's paychecks. If you have a CBA, you have to reach out to your union representatives now to coordinate the deductions. And it's also important, vitally important, to designate staff and educate them on how to process claims for PFL in coordination with the FMLA and any other applicable disability workers' comp benefits. We recognize that this new law brings more forms and more notices and more scenarios that an employer will need to assess and determine. So, it's important that if you have any questions or if you're unsure about how this is going to apply in practice, that you reach out to your HR professionals or attorneys to help you walk through this complicated area. We'd be happy to walk it through with you. We've looked at this and all the underlying guidances and materials, and we'd be happy to walk through this with you. Like everything else in the employment context, it is vitally important to understand this because missteps could cause problems later on. And we've in the last 3 decades have developed a practice here that works, we think, very efficiently with employers in identifying what they have to do in a practical, upfront fashion. So again, if you have any questions or if you have any concerns or you want to in any way have questions and things that you don't want to ask on this website, and we apologize for running over, you can email either Marianne or I. Our emails are here. We'd be happy to answer whatever questions you have. Thank you very much for your time, and we apologize for going over. Thank you.
Bye-bye.